Hey everyone, it's Rob Ryder. First of all, if you hear humming in the background, I apologize. My microphone's going bad, and it's the only one I got. And sometimes to me this stuff is more important than being said than maybe the noise in the background. So here we go. If you have an issue, it looks like the arbitration, which is just one of the many names you could use for an administrative hearing, is actually where you're going to find equity. We're going to go through some examples of this, but to start with, we're going to just look at some definitions that came from Arizona, revised statute 411092, where it says, like it says, administrative law judge means an individual or agency head, board, or commission that sits as an administrative law judge that conducts administrative hearings in a contested case or an appealable agency action that makes decisions regarding the contested case or appealable agency action. And I had read before that there's only two things that the judicial branch gets involved in, and that is interpreting the statutes or codes or whatever that the legislature has created. They interpret the law. That's what the courts do. And they judge contested matters. There you go. So, this is a contested matter. And where the arbitration center is, we're in Illinois, in Kane County, Illinois. Apparently, when you walk into the wing there, it's got a big-ass sign of the Supreme Court on the wall. And the Supreme Court is renting these particular rooms from the county of Kane to run the the arbitration court, basically. So some places called arbitration court, some places it could be called mediation, it could be called case evaluation, it could just be called administrative tribunal, it could be called a municipal court. But it's the place where the administrative law judge's decisions means the findings of fact and conclusions of law. Well, isn't that what we're looking for? Someone to look at the facts, make a determination and a conclusion, and recommendations or decisions issued by an administrative law judge. It's really like a justice of the peace, right? He's the guy you take your probable cause to, and based on probable cause, he'll call the other party in for them to answer. And it's just that we never get these notices to go to this hearing, and then by following the red cape instead of where the matador is, we go into this door over here to this court that has nothing to do with the first place you needed to be, which is the administrative court, because we're talking about ordinance violations and civil infractions and traffic citations and this kind of stuff. That's all being done in an administrative court, be it municipal court, whatever they call it. And if it's a case that has gone to arbitration, it's mandatory that you appear as the defendant. If you don't appear, that's where the default judgment comes from. And then they move it into this other court to get it, so that this is like the first level. Okay, we've looked at it, this is what we decided, and then they'll get a final determination by a judge. But when he puts his seal on it, boom, it's done deal. And so you need to go to the arbitration court to appeal a traffic ticket or your foreclosure or your disorderly conduct or whatever it is. So we'll get into it more. Appealable agency action means an action that determines the legal rights, duties, privileges of a party, and that is not a contested case. Right? So it's not appealable. It's not really contested. They've given you a ticket. Right? Some agency's given you a ticket that says you have a legal right, duty, or whatever to pay this ticket, and you're going to go there and appeal that decision and say, well, only a peace officer can arrest me, and I don't see any names on here. Where's the full name of the peace officer that gave me this citation? Doesn't have their full name on it, then it's a simulated legal process. It's somebody who's apparently false personation of a peace officer. And it is Wednesday, October 12th, 2014. I am Rob Ryder. Well, actually, I'm not, but that's what I go by. And my email address is courtofrecord@aol.com. My phone number, 616-712-6179. If you can, please, PayPal account name for a donation is Ashley Rytlewski at gmail.com. That's ASHLEYRYTLEWSKI at gmail.com. Or snail mail to myself, Robert Rytlewski, 10955 14 Mill Road, Rockford, Michigan, 49341. And then I might be able to get a new headset and it wouldn't hum so bad. But I have to pay my rent first, and it always seems to be the dilemma. Okay, I can attest that research doesn't pay well. But it doesn't matter. Not in it for the money. What I'm in it for is to show them devil-worshipping pagans that the children of God are waking up, and we're going to figure out what they did, where it happened, and take a system that's already built that is really unbiased. It's just there's people willing to lie, cheat, and steal to use it, and point out that they're lying, cheating, and stealing, and see what happens. So in Arizona, to start with, they have a place called the Arizona Office of Administrative Hearings, and it has its own website. You can Google it. In there, it gives the section of laws that have to do with why they can do what they do and so forth and so on, and that's where this comes from, is off of that website. And then there's other interesting things there. That's why I would say, well, go look at Arizona Office of Administrative Hearings. Now, they're not all set up the same, right? This is the way it's done in Arizona. And we just read these, right? In a contested case or appealable agency action, administrative law judge decision means the findings of fact, conclusions of law, and to me that's the all-important thing, is that part right there. Right? I want to take him the facts and have him determine the facts if I'm actually committed a crime or if they've committed a crime. Appealable agency action means any action that determines legal rights, duties, privileges, party, and that is not contested. Appealable agency actions do not include interim orders by self-supporting regulatory blah, 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 internal management. Okay. For the purpose of this paragraph, administrative hearing does not include a public hearing held for the purpose of receiving public comment on a proposed agency action. So this has nothing to do with the township board. Each state agency and each political subdivision contracting for office services pursuant to this subsection of this section shall make its facilities available as necessary for use by the office in conducting proceedings pursuant to this article. So, the office, Arizona Office of Administrative Hearings, would have the hearings even in a political subdivision like a city. They may call it a municipal court, but it's still going to be somebody who's been selected by this group, director of this organization. Right? So it says municipal court on the wall, on the sign, but it's actually part of the Arizona Office of Administrative Hearings. It's my opinion, just by reading what it says. Right? So all these things are yet to be determined, but that's how we do things, right? We go look for things and say, okay, what could we maybe do with this set of facts? Okay, if the office cannot furnish, okay, administrative law judge properly is responsible to the agency request. Director may contract with qualified individuals to serve as temporary administrative law judges. If we just need them for a day, then make a phone call and they'll send them somebody to an attorney who's on a list, who's taken a test to be an administrative law judge. They'll call out and say, hey, we got a job for you. Some places will have a judge here all the time. The office may provide administrative law judges on contract basis to any government entity to conduct any hearing not covered by this article. The director may enter into contracts with political subdivisions of the state, and these political subdivisions may contract with the director for the purposes of providing administrative law judges and reporters for administrative proceedings or informal dispute resolution, ADR. This is all supposed to be like non-judicial, like before you've gone to the magistrate, and technically it's quite biblical to do that. You have a controversy with your brother, you go there first. The second time you go with 2 or 3 witnesses to establish every word. That's what this is. If that doesn't work, well then you go to the magistrate. But this is an administrative law judge. It's not a judicial, right? It's a different branch of government. Somebody's going to execute the law. And then if there's a controversy from there, he has a judge above him that can make the judicial determination. This is the entry point. This article applies to all contested cases as defined in some other section and appealable agency actions. Right? State Board, Department of Corrections, Executive Clemency, Industrial Commission of Arizona, the Corporation Commission, Board of Regents, State Personnel Board, Department of Juvenile Corrections, Department of Transportation. Right? You get a ticket from a state cop. The Department of Transportation has its own administrative hearing. Right? That's where you're supposed to go to. And if you have a ticket in a municipality, an abstract of the judgment is supposed to go to the Department of Transportation, but the municipality itself may have its own court, or have its own municipal court. Department of Economic Security, Department of Revenue regarding income tax or withholding tax, right? So all this tax stuff, Board of Fingerprinting, all this stuff is done administrative hearings, just different types. And so like in Illinois, it says any civil case between 10 and 50,000 is mandatory arbitration, and any small claim which is less than 10,000 is mandatory arbitration if they've asked for a jury. Other cases can be sent to arbitration just by asking the judge to put it on the arbitration schedule. And if they do that, it's going to have a civil case number on it, but it's going to be over in the arbitration administrator's files, not necessarily the court clerk's files where you've been going to. And that's the difference between public and private, because everything done in the administrative side is all private. You won't find those records online. Doesn't mean they don't exist, they're just not putting them online. It's a private record. You've been looking for public and private. It's the difference between an administrative court and a judicial court. Notice of appealable agency action or contested case hearing, informal settlement conference. Any agency shall serve notice of appealable agency action or contested pursuant to sections whatever. So this is just telling you how they're supposed to let you know, but it's going to identify the statute or rule, identify the reasonable particular of the nature of the alleged violation, include a description of the party's rights to request a hearing, include descriptive of party's rights to request an informal settlement conference. Alright, so that's the stuff that should be on a ticket, let's say, or civil violation, civil infraction, citation, whatever it is. And if you hold it upside down and look at it in a mirror, maybe it does say that. Right? It probably could. They could probably say, well, it says it right here, and say, okay, you take 4 words out of a sentence and say it says all those things. And you're looking at this whole other piece of paper that says it's a ticket, and really they're going to use it as a notice of an appealable agency action that you're supposed to go to the administrative court to take care of. And what you're going to do with that damn ticket is go down there and say, hey, the dude didn't sign this ticket. Right? This is false personation of a peace officer. Right? That's my answer to the ticket. There is no ticket. By what authority did he bring this charge? If it's the and Bobby in Arizona has already proved this. He went and he looked up the assistant city attorney who sat there in his traffic case, or who he had to deal with in this traffic case. Looked at his name. He called the clerk of the Supreme Court of Arizona. I think it's called the Supreme Court. It said, "Is this dude an attorney on your roll of attorneys?" And they came back and said, "No, he isn't." He said, "Well, how can that be? How can that be? I'm reading the Surprise City website, and here's his name, and it says that he is the assistant city attorney." And they said to her, "Well, like we told you, he's not on our list." And then they said, "I suggest you call," and it would be whatever their grievance commission was. And he hasn't done it yet, but it's like, okay, we got that, we're moving on, let's see what else we can get. What we're trying to do is find out where the cases go to, right? So it looks like what they did is they take these cases into arbitration. And you don't show up for this administrative hearing. And because you didn't show up, and it's mandatory that you show up, they get a default judgment. Now that default judgment, the administrative judge can give an award. And that award, for it to be final, the supervising judge, who's over these administrative judges, has to, bless it off. And he isn't going to do it unless he's asked to. I'll get into that a little bit deeper on the next thing we look at, but just to give you an idea of what it is we're dealing with. A party may obtain a hearing on an appealable agency action or contested case by filing a notice of appeal or request for a hearing with the agency within 30 days after receiving the notice prescribed in subsection A, yada, yada, yada. So if you just got a ticket, I would be doing this, right? Be asking for a hearing. A party may obtain a hearing on an appealable agency action. You get a ticket, it's appealable. Or contested case by filing a notice of appeal or request for hearing with the agency within 30 days after receiving the notice prescribed in subsection A of this section. The notice of appeal or request for hearing may be filed by the party whose legal rights, duties, privileges were determined by the appealable action of a contested case. They pulled you over DUI, you had 2 beers, right? DUI. Did you know that that's actually, it could be called a DUI, driving under influence, but it could just as easily be called public intoxication. And intoxication is an ordinance violation. A notice of appeal or request for a hearing may also be filed by a party who will be adversely affected by the appealed agency's action or contested case, or who exercise any right providing law or comment on the action. Right? Yeah, you're going to you're going to damage my rights by charging my brother falsely, right? So now you can go help your brother out. You just need to appeal. And so I'm not here to get into the depths of how it's done. I'm pointing it out so you go read it, make some phone calls, and figure out how it's done and tell me. And I'll put it on a video. If a good cause is shown, an agency head may accept an appeal or request for a hearing that is not filed in a timely manner. Well, you missed your filing date. You know what? I was never told I was supposed to be here. I didn't get proper notice. I went to that building over there. It says city court on it. I didn't realize I was supposed to go inside the building to the one called the municipal court. It's crazy how they do this stuff. All right, here's a biggie. It is not required by law. This section does not apply to a contested case if the agency initiates the contested case hearing pursuant to law other than this chapter and not in response to a request by another party. It is not required by law other than this chapter to provide an opportunity for an administrative hearing before taking action that determines the legal rights, duties, privileges of an applicant for the license. You're not going to find this written anywhere else than right here in this chapter, that it says it's required that they do that. It is not required by law other than this chapter. So this is the chapter you would quote to say, hey, I was supposed to be able to appeal this ticket, and you never told me that because it's not on the frickin' ticket. Or whatever your 5 seconds of spiel is to say I'm appealing the case. It is not required by law other than this section to provide an opportunity for an administrative hearing before taking action that determines the legal rights, duties, privileges of an applicant for a license. Determine if they're dicking around with your driver's license because of a DUI, this is the only place where it says, hey, you were supposed to have an administrative hearing to determine if they could dick with your license because of a DUI. Or whatever other kind of license you got, apparently. Service of documents, unless otherwise provided in this article, every notice or decision under this article shall be served by personal delivery or certified mail, return receipt requested, or by any other method. Right? So lots of ways they could do it. The question is, do they do it? Each party shall inform the agency and office of any change of address within 5 days, because if they're using the address of record with the agency and it's not your address, you're not going to get it. And you know where the agency gets their address? All these addresses come from the Social Security Department. You have a master file in Social Security. I don't remember the number. I just went and asked for mine. I have to do a video on it here whenever I get it. But in there, it talks about all these different entities that use the address that's on the application. Whatever that means, we'll find out when we get the record. Is it the same as the SS5 or is it something else? They're going to use that as your address, and it goes to DMV, it goes to, well, pretty much everywhere. I'm not going to go through all the places it goes. It's just a bunch of them. It's like 40 places listed at least that the information goes to. It isn't from them to Social Security. It's from Social Security to them, and it's all based on this one record. And one of them is anything to do with your driver's license, looks like, voting, so forth. Addresses had to do with what Social Security has. And so getting that record correct would correct all the other records. We're not quite there yet. If requested by an appellant or appellable action or respondent in a contested case, right? Appeals of agency actions and contested cases, informal settlement conferences, ADRs, applicability. If requested by the appellant or appealable agency of an appealable agency action or the respondent in a contested case, and so that would be more like a foreclosure, where somebody's saying, hey, you owe me money. Because when you read a foreclosure, they're saying you have a debt. They're debt collectors. It's a money judgment. Now, I don't know how they get there, but if you're wondering why these states have non-judicial foreclosures, well, they're still having an administrative hearing, and you're not going to the administrative courts to deal with it. You're trying to go to the judicial courts. Okay, motions. Compose motions or respond to motions online. All communication with the administrative law judge must be in writing. Use the e-motion form in the above link to communicate with the administrative law judge or to request action to be taken on a case. Examples of such request actions are request to appear telephonically, motions to continue, motions to vacate, a hearing request or interpreter, etc. You may add attachments. You don't need to go to court. You can do it online. And I know that a lot of people in Florida were on these telephonic foreclosures. Well, they're talking to some dude on the telephone. They went to court, and the attorney's sitting in his office. Well, they could have been sitting at home too, but they didn't. They never appeared in the administrative hearing, and so they never got a chance to do this stuff. So, okay. Good stuff, man. I mean, this is really how it all fits together. Let's look at okay. Then we'll move on to away from Arizona. We're not saved properly before. Reader shut down. Click yes to open. That's okay. I could have left that open. And where is the other one? Right here. Oh, just a minute, please. Okay. Arizona Criminal Justice Commission, statewide criminal justice directory. And for now, we're going to just look at. So these are city courts. Let me go back real quick. All right, table of contents. They got city courts, city police, city prosecutors, yada yada yada. But what? And then they got the superior courts, probation departments, Supreme Court. I haven't looked at all these, but one that was interesting is the city courts, because when you get to the page that says city courts, right, they're called municipal courts. Municipal court, municipal court, municipal court, municipal court, municipal court. And we get to our subject for today. It is Surprise Municipal Court. Louis Frank Dominguez, presiding judge. And on the address, see, it's got Suite 105. Now, if we go to this, which is a flyer that was put out by Surprise. All right, here's Surprise City Court. So if you walk up to the building, you see this sign here that says Surprise City Court. Right? But that isn't what it's called. It's called the Surprise Municipal Court, Suite 105. Well, I can tell you this is the same address, but there's no Suite 105. Right? This is the Superior City Court judge, presiding judge. He appears to be the administrative law judge, right? But if you go in this door here, this isn't necessarily Suite 105. Is the point? And this is where Bobby went to. He walked in this door to go to court, when maybe what he should have done was walk through the building to find Suite 105 to find the municipal court, because he doesn't want it's a Surprise City Court. Right? It says Surprise City Court. That isn't what he wants. He wants the municipal court of the city of Surprise. Surprise Municipal Court. And boom, right? They just sent you the wrong room. In Illinois, in Kane County, all the arbitration courtrooms are on the second floor. But when you go to court, it's mainly on the first floor. Right? Nobody goes into these courtrooms. Don't show up on the list of courtrooms that are under the chief judge of the county. They're not on her schedule. And on the wall is a big ass seal from the Supreme Court of the state of Illinois, Supreme Court of Illinois, who says they run it and they rented the property. Okay, but so on the back of this, then it goes through civil, traffic, options. So it's not civil traffic, it's civil and traffic, basically. And your rights and duties in court. So you may want to look for something like this if you're in Arizona, especially, and you live in a city that has a municipal court. Right? One thing to look at is did I close that already? What the hell's wrong with me? Get this other one to open up again. Oh, criminal justice. There it is. Arizona Criminal Justice Commission 2014 Statewide Criminal Justice Directory. And if you have a city court, there you go. Now, I don't know how it works with the sheriff, if he's built into this too or not, but they're all going to have some kind of administrative tribunal. Okay, let's move on. Moving on then. Now we're going to look at mandatory arbitration, Illinois. Mandatory arbitration proceedings. Now this is the local court. This here we're looking at our local court rules to Kane County, Illinois. They could be different places. However, mandatory arbitration proceedings governed by Illinois Supreme Court. They're govern it. Their rules. The mandatory arbitration program in the circuit court for the 16th Judicial Circuit, Kane County, Illinois, because they have for and they have of. When you look at the names, the captions on the paperwork, some of them say for the 16th Judicial Circuit, some of them say of. So the mandatory arbitration program in the circuit court for the 16th Judicial Circuit, Kane County, Illinois, to me must be the Supreme Court. And it's going to follow these rules, 86 through 95, conducted the mandatory arbitration. Arbitration proceedings shall be governed by Supreme Court rules and by local court rules. And we're kind of looking, that's what this is right here, local court rule. At least I believe it is. I'm going to ask them, all right? The idea now is to go to the arbitration window and say, I want a copy of the local court rules that these proceedings are governed by and see if this is what they give you. Civil action subject to mandatory arbitration. Mandatory arbitration proceedings are undertaken and conducted in the 16th Judicial Circuit, Kane County, pursuant to approval of the Illinois Supreme Court. I need to show you the difference, so I need to go get a copy. Hang on a second. Sorry. Okay. This was the original complaint that they hit row with to start this whole fiasco off, and it says, in the circuit court for the 16th Judicial Circuit, Kane County, Illinois. All right, so that's the place that it went into, we're going to say. They made a decision, or somebody made a decision, or whatever they did, that this is an arbitration case, and the arbitration cases are heard in the courts in the 16th Judicial Circuit. And so one of the other pieces of paper she ended up signing was in the circuit court of the 16th Judicial Circuit. Right? Well, of is in. It's a circuit court of the 16th Judicial Circuit. The other one is for the 16th Judicial Circuit. And this is the one that it says where she gave $120. It should have been for a cash bond, bail, and they put it down as a 10% bond, or 10% payment on a bond for $1,200, right? Bail set at. And when you read her, what Class C misdemeanor, what it was, it should have been $120 cash bail. Then they made her sign. So this is the only thing she had to sign to get out of jail. She hadn't even seen this yet. Didn't even know this existed, right? The only paper she saw on the day she was arrested illegally, extorted, is here, and she signed her name right there, and it says in the second paragraph, I, the undersigned defendant, do hereby acknowledge myself to be indebted to the people of Illinois, or the city, or village, set forth as a municipal corporation in the sum indicated as bail. Right? They say the bail was $1,200. Right? What else did they say? They said that the people of Illinois, or city, or village, set forth as a municipal corporation. So in other words, the people of Illinois is a municipal corporation, or a city could have been, or the village, but it's the people of Illinois. And this went into is basically the arbitration court. Using the defendant as that name. So, we don't know exactly what this is yet, other than, hey, this is what they're getting you for. That now it's a money judgment. Forget the $30, $35 fine for disorderly conduct. Now it's a money judgment for $1,200 because you signed a piece of paper that said you were indebted to the people of Illinois. People of Illinois, not the people of Illinois, if there ever was such a thing, because up here it's people of the state of Illinois. Well, that isn't what it says. That's who's supposed to be the plaintiff. Well, if they're the plaintiff, how come it's going to the people? People of Illinois. It's interesting. Enough on that. Back at it. The other thing is, just real quick, I don't know if I'm going to find it as we're going, but when I was looking at some of the different counties to see what they did for this arbitration, they used a GEN number as an arbitration case number. So 13-17026 is an arbitration case number in arbitration. Apparently. Okay. What else is going on? Mandatory arbitration proceedings are part of the underlying civil action. There you go. All right, it's just part of the action. That's how it works. Can't get away from it. All civil actions exclusively for money between 10 and 50, they're mandatory. Cases not originally assigned to arbitration calendar may be ordered to arbitration on motion of either party, by agreement of the parties, or by court order. Right? So all one party needs to do is motion and say that they told you and you not know it, and now it's over in the arbitration on the second floor instead of on the first floor. You went to the wrong courtroom, you didn't put your paper into the right clerk, yada yada yada. All these things start to add up. When a civil action not originally assigned to the arbitration calendar is subsequently assigned to the arbitration calendar pursuant to Supreme Court Rule 86D, the arbitration administrator shall promptly assign an arbitration hearing date. Okay, now there's somebody we need to find, the arbitration administrator. All right, let's call it the clerk of arbitration. But they call it arbitration administrator. Use the word. And this arbitration calendar, right? We haven't seen one of those yet. And you know why? Because everything in arbitration is private. Just seems to be the way it works. Applicants shall be eligible appointment of arbitration panelist. There's usually 3 of these guys on a panel. That's a tribunal. Upon filing of any civil action subject to this article, the clerk of the circuit court shall set a return date for summons not less than 21 days nor more than 40 days after filing, returnable before the judge designated to hear arbitration cases by the supervising judge for arbitration. So when you get a summons from the clerk, shall set a return date, okay, that should be on the summons. Not less than 21 days, not more than 40, somewhere in there. Now why is it 21 days? We'll have to figure that out. But that's the day that you're supposed to go before the judge designated by the supervising judge of arbitration for an arbitration hearing. Not into the frickin' courtroom on the first floor, right? Some court on the second floor. Here, because that's where these courts are at, the rooms are at. Upon the return day of the summons and court finding all the parties have appeared, the court shall assign next available arbitration hearing date. Consolidated cases shall be heard on the hearing date assigned to the latest case. All parties shall comply with provisions of Supreme Court Rule 222, which is pretty good stuff. Party may offer evidence without foundation of proof for things like bills, records, reports. So this is talking about the conduct of a hearing, and this is what the plaintiff is supposed to supply in the case. Bills, records, reports, bills for drugs, property repair bills, right? Substantiate your case, your claim. Written statement of an opinion of a witness, any other document not specifically covered by the foregoing provisions for which otherwise admissible under rules of evidence. What's the evidence? A panel shall render its decision and enter an award on the same day as the hearing. Now it talks in here if you don't show up. Now we're going to get to something that explains that better, but rejection of arbitration award shall be in strict compliance with Supreme Court rules. All forms shall be as prescribed by the Supreme Court rule and by administrative general order by the chief judge, not inconsistent with any Supreme Court rule. So I would, at least to start with, find the administrator of the arbitration and ask him for the forms. Administration of mandatory arbitration. Chief Judge of the 16th Judicial Circuit shall designate an arbitration administrator or an assistant deemed necessary for a mandatory arbitration system. Well, there you go, right? It's in the law. Certain cases are automatically, in Illinois, they're mandatory to go to arbitration. Money judgments less than $50,000, between 10 and 50. Small claims which are less than 10. Small claims are less than 10 that a jury's been asked for. Okay, before I forget, now we'll look at this just real quick. This is Kane County. It's a leasee agreement. Regarding the lease dated between the State of Illinois, the 16th Judicial Mandatory Arbitration, through its authorized agent, Administrative Office of the Illinois Courts. Right, that's the Administrative Office of the Illinois Courts, which is the administrator appointed by the Supreme Court to administer the courts. And the Kane County Board. The premise located, North Wing, 2nd floor, Kane County Courthouse, rooms 200, 210, 11, 13, 14, 20, and 22, located at 100 3rd Street, in the city of Geneva, in the county of Kane, in the state of Illinois. That is the address and the building of the Kane County Courthouse. And the Supreme Court, through its administrative office, is going to lease space for these courts. Now, one thing they did, though, is they used to have 200, 210, 211, and now they're going down to 210, 211, 212, 214. I don't know what happened, right? But that's all they're doing now is those courts. And I believe that the administrator sits in room 211. All right, so the administrator is sitting in a room that's rented by the administration, what do they call it? Administrative Office of the Illinois Courts, chief administrator for the court system. Right, Administrative Office of the Illinois Courts, Supreme Court of Illinois, Administrative Office of the Illinois Courts. Whereas Illinois Supreme Court wishes, right? Whereas the Illinois Supreme Court wishes to utilize certain space located in the 3rd Street Courthouse. Well, whose court is it? It's the Supreme Court. Whereas the county of Kane, not Kane County or all these other things, the county of Kane has the authority to lease. Then why are you talking to Kane County is my question, but it's okay. Margaret Wheaton, Arbitration Administrator. I think that's who she is. Okay, but there you go, right? They leased some space. Now, this will blow you away. So did the U.S. Bankruptcy Court. We're not going to be getting into this, but just so you know, whereas the U.S. Bankruptcy Court for the Northern District of Illinois wishes to utilize certain space located in the 3rd Street Courthouse for purposes of hearing cases by entering into a memorandum of understanding. How many people knew that they had a courthouse in their county courthouse? I guess they could have. I mean, I've not been to a bankruptcy court, but I went through a bankruptcy. I just never went. I hired an attorney. Duh. Whereas the United States Bank would pay County of Kane $5,000 per year for the use of the courthouse. That's a sweetheart deal to run the whole scam. Look at we'll just go look at some rules real quick. This is the rules of how that works for the Supreme Court. Since they're the ones running the show, what's the Supreme Court say? A civil action shall be subject to mandatory arbitration if each claim therein is exclusively for money in an amount or value not in excess of the monetary limits authorized by the Supreme Court, which I think is like $50,000. That just means it's mandatory. It doesn't mean you can't voluntarily put it there, but mandatorily, that's how it gets there. Each judicial circuit court may adopt rules for conduct of arbitration proceedings which are consistent with these rules and may determine which matters within general classification eligible action shall be heard in arbitration. Assignment from pretrials, cases not assigned to the calendar, may be ordered to arbitration at a status call, pretrial conference when it appears, or a pretrial conference when it appears to court that no claim in the action has a value in excess of monetary amount. So the judge could issue an order, but because you've never properly appeared, right, because people are afraid of appearing in court, you're not going to get the notice that, well, we just went ahead and moved it over to arbitration. He's going to issue an order. Notwithstanding that any action upon filing is initially placed in the arbitration tract or thereafter so designated for hearing, the provisions of the Code, civil procedures, the rules, Supreme Court shall be applicable. Appointment, qualification, compensation of arbitrators. A panel of arbitrators consists of 3 persons or 3 members of the bar, or such lesser number as may be agreed upon by the parties. Scheduling of hearings. Hearings shall not be held on a scheduled date and within 1 year of the date of the filing of action unless continued by the court for good cause shown. Shall be held on the scheduled date and within 1 year of the date. Okay. Discovery per Rule 222. Conduct of the hearings. Power of arbitrators. The arbitrator shall have the power to administer oaths, affirmations to witnesses, to determine the admissibility of evidence, and to decide the law and the facts of the case. That's what the bishop did. He decided the law and the facts. All documents referred to under the provision shall be accompanied by a summary cover sheet listing each item that is included, detailing the money damages incurred, right? So again, if you're going to make a claim, well, now you need to put it on paper. So if anybody put a claim in against you and you haven't found it, it's going to be in the administrative court. And when you read it, it might be, oh, if you pay this attorney the $10 he was supposed to get for doing something, he can release this lien that would give you your property back, or whatever the hell it is. You may have a non-monetary obligation of some kind. A mortgager is defined as, somebody you owe money to, or you have a non-monetary obligation. You got to give him a nod of the head, a wink of the eye, whatever it is, to get him to be able to release something so he can be paid, because he hasn't been paid yet. That's what they're saying. Any other document not specifically covered, okay, so forth and so on. The pages of any Rule 90C package submitted to the arbitrator should be numbered consecutively from the first page to the last page of the package, in addition to any separate numbering of the pages, individual documents comprising such packaging. Right to subpoena the maker of the document. So now you're going to go look and you're going to find stuff, and you have the right to subpoena the maker of the document and put his ass under oath. Any other party may subpoena the author or maker of a document, admissible under this rule. Compelling appearance of a witness. Right? They can subpoena them. If they don't do it, well, they're going to use the power of the subpoena. Remedies upon parties' failure to comply with notice pursuant to 237B may include an order debarring the party from rejecting the award. And this is kind of what that cover sheet would look like in the Circuit Court of. And so what we want to know is, what is this supposed to say in the Circuit Court of Kane County, Illinois, and the Circuit Court of the 16th Judicial Circuit, Kane County, Illinois. I don't know. But see, it doesn't say case number here. It says NO. And then you just list. This is a list of the bills you would have, or whatever your information is going to be. It's a cover sheet. Absence of a party at the hearing. Failure to be present at the hearing. The arbitration hearing shall proceed in the absence of any party who, after due diligence, fails to be present. The panel shall require the other party or parties to submit such evidence as the panel may require for making an award. The failure of a party to be present, either in person or by counsel, at the arbitration hearing shall constitute a waiver of the right to reject the award and consent to the entry by the court of a judgment on the award. And one thing about a corporation, I don't know if it's in here or not, but if it's a corporation that's there, they have to be represented by their attorney. And as soon as their attorney shows up, you look at them and say, I need your certificate of good standing, because by what authority do you say that you're their attorney? You want the certificate of good standing, if there is such a thing, or the certificate from the clerk of the Supreme Court, where the roll of attorneys is kept, to get a copy to see how that attorney put the name on the damn document. And if they use their middle name on their certificate from the clerk for their commission as an attorney, because they're an officer at the court, then that better be how they're signing papers. They better not be using an initial. If they're using an initial, we could say one of two things. It's either misconduct of a public officer, or it's the false personation of one. And I think we want to say, hey, that's false personation. You were never an attorney under this name, right? It's not that any kind of misconduct in your part. No, 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 no. Everything you did under this name is a false personation, and you need to give all that back, right? Or the same with the judge. The judge is using the middle initial, and they need to be an attorney at law to be a judge, and you go and find out that on their license it says that they use their full middle name, and they're using an initial. Well, then this person was never a judge. It's false personation of a judicial officer. In the event the party who fails to be present thereafter moves or files a petition to court to vacate the judgment, as provided therefore under provisions of the Code of Civil Procedures, vacation judgment by default, sections whatever, the court in its discretion, in addition to vacating the judgment, may order the matter for rehearing in arbitration, and may also impose sanctions of costs and fees as a condition for granting such relief. Okay. Right? In the event the party who fails to appear, so you've never appeared, and now you're going to file a petition, which is a motion, because when they say motions, they cover petitions and all sorts of things. So to vacate the judgment according to these rules, which will tell you how to do it, why you can do it, and you can say because you never got proper notice. Right? Now the judge could say, well, okay, we're going to charge you for that, but I don't believe they're going to. So these motions, though, go to the supervising judge. They don't go to the hearing officer. Good faith participation. All parties to an arbitration hearing must participate in the hearing in good faith and in a meaningful manner. If you don't show up, if you don't appear, then you didn't participate in good faith. Such an award shall be prima facie evidence the party failed to participate in the arbitration hearing in good faith and in a meaningful manner and a court. When presented with a petition for sanctions remedy, therefore, may order sanctions as provided by Rule 219. There is a precedence for such rule, and its consequence in the rules of other jurisdictions, like Ohio, has long had a rule which provides a failure of a party to appear at the hearing either in person or by counsel. See, it didn't say by attorney, it said or by counsel. Constitutes a waiver of his rights to reject the award and demand a trial, and further operates as a consent to the entry of judgment on the award. Important thing to understand, when the clerk of the Supreme Court has a certificate that they can give that says that this attorney, if they have done this, right, is authorized as an attorney and counselor at law. And you go and look at the definitions of an attorney and a counselor, and an attorney represents you. He doesn't give you legal advice, he becomes you. He represents you, and he says, I want to give my property away, and signs your name. You're going to give him power of attorney for him to be you. Where a counselor gives you legal advice. Right? He isn't you, he gives you legal advice for you. And so there are, I'm sure, in fact there are plenty of attorneys that have a license. But the question is, are they using the name that's on the license when they're signing the papers? And it looks like some, very few, but some of them do. That's probably significant. There's a good case, there's others that don't have a license. Roe had told me that her public defender, when we were bringing this up to her public defender, told her she never signed a oath of office. She didn't subscribe an oath. Well, you don't just raise your hand and say the words. You got to put it on paper. There has to be a memorial to the event, and apparently there isn't. To permit any party or counsel to ignore the arbitration hearing or exhibit an indifference to its conduct would permit a mockery for this. Right. So this is why you have to show up, because you would be mocking the court system if you didn't show up. party who knowingly fails to attend a scheduled hearing, either in person or by counsel, must be deemed to have done so with full knowledge of the consequences and in here with this rule. So the court's going to presume that you were properly noticed and you decided not to show up. And you need to rebut the presumption by going back and putting in a motion that needs to be heard by the supervising judge. It doesn't go to the arbitration panel. They don't hear motions. They just determine facts and law. The motions are okayed by the supervising judge of the arbitration panel. Award and judgment on award. Determining award. The panel shall make an award promptly upon termination of the hearing. The award shall dispose of all claims for relief. Judgment on the award. In the event none of the parties files a notice of rejection of the award and request to proceed to trial within the time required therein, any party thereafter may move the court to enter a judgment on the award. So the award could have been made, but it hasn't had the final judgment. And the award could be, yeah, we find you guilty of disorderly conduct, pay $35. Well, you could do that, or you can go to jail. Which one are you going to do? You can contest it, say, well, they didn't, go through the whole thing, or you could just pay it right there and it's done. Same thing with a foreclosure. It may be, well, they didn't pay this $20. In Bob's case in Arizona, if I remember right, there was a lien for $10 against the original builder of the subdivision, where he was supposed to pay $10 for every lot as part of a advertising program or something like that. And they didn't, and there's this $10 lien, and until that lien was gone, you couldn't get the certificate of occupancy. Well, we went down before trying to get a certificate of occupancy and got blown away because, they went through the wrong door, basically. They just said, well, we don't do those anymore. Right? It doesn't matter that it says it in the frickin' code. They just don't do it. That's the custom. Right? So, now we're learning what we're supposed to do about that. But at the time, we didn't. But there you go. You don't have a certificate of occupancy for your house. Right? It's not ready to be moved in, so you can't technically be living there. And they can throw you out for that ordinance violation. Right? You're vagrants living in a house that isn't ready for occupancy. It doesn't matter how long you've been there. So you go, and so here's the thing. So now we have this thing called the award. Right? So let's say your case has already happened. You go find the arbitration administrator and ask her what the award was for the case. And she's supposed to take it and file it with the clerk of the court. And when they say clerk of the court, I believe they mean the clerk of the superior or Supreme Court, because this is all run by the Supreme Court. But it doesn't say that. It just says the clerk of the court. Correction of an award. When the record of award discloses an obvious or error, that can be fixed, okay. Rejection of the award. Within 30 days after filing of an award with the clerk of the court, right? So the award has been filed with the clerk of the court. Well, who is that? Well, since, again, this is under the Supreme Court, I'm saying that's who we're talking about. And upon payment to the clerk for the sum of $200 if it's less than $30,000, or $500 if it's greater than $30,000. Any party who was present at the arbitration hearing, either in person or counsel, may file with the clerk a written notice of rejection of the award and request to proceed to trial. They could do that. I don't know if they have, but they could. A form of oath, award, right? So they do an oath in the circuit court of the blank judicial circuit, right? So I guess that's how you do it, in the circuit court of the 16th Judicial Circuit, Kane County, Illinois, or the Circuit Court of Cook County, Illinois. So the two must be the same, right? When you say it the one way, it's the same as saying Circuit Court of Cook County, Illinois, because we're really looking for the county court, and circuit does mean county. That's what the Circuit Court clerk told us. To him, it meant county. Awards arbitrators, the oath. yada yada yada, different forms, but we're not going through all that. I just want to point out a few more things. Oh, and then the next thing is you have arbitration, but there's also mediation. I'm not really sure what the difference is, but there is. But at the end of the day, you got arbitration and mediation. Divorces are mediated. That's a mediation, right? So these are all what they call alternative dispute resolution, ADRs. Mortgage foreclosure mediation. Now everybody has an idea what that's for, but who's gone there and said, well, let me see the evidence that these guys have that I have a contract with them, instead of waiting and doing that in court. All right. Now, in Michigan, Oakland County Circuit Court, District Court case evaluations, right? They don't call it arbitration, they call it case evaluation. What's the purpose behind case evaluation? It's to recommend awards that will result in settlement of cases. Well, shit, I thought that was what arbitration was. Well, it is. Case evaluation of tort cases filed in the circuit court is mandatory, beginning with actions filed after the effective dates of whatever. Right? All tort cases in the lowercase circuit court. So it's not the 16th Judicial Circuit or some other, it's the lowercase circuit court, which should be the circuit court of the, let's call it the district. Right, they're all in the same building. These are just different jurisdictions. This is like the territorial court. All torts filed with the circuit court. So we call it the Circuit Court of Bay County, Circuit Court of something county, not the 16th Circuit Court. I think it would just be when they say the Circuit Court of the County of Bay, Circuit Court of the County of Kent, because I've seen that on headings before. So I think in Michigan that's what we're talking about. The Circuit Court of the County of whatever this was. Who are we looking at here? Oakland. The judge to whom an action is assigned or the chief judge may select it for case evaluation by written order no earlier than 91 days after the filing of an answer. Right? However, if it's mandatory, it's already there. It doesn't matter. Right? There is no B. It was done by A. The court may submit to case evaluation any civil action in which the relief sought is primarily money damages or the division of property. And most people that get foreclosed on in Michigan, it's using landlord-tenant statutes. And all that is who has possession of the property and back rent. Right? So the division of property, well, okay, who's got possession of the property? And money damages for the back rent. There you go. It goes to arbitration. Case evaluation of tort cases filed in the circuit court is mandatory beginning with, right? Doesn't matter anything else, it's mandatory. Cases filed in the district court may be submitted to case evaluation under this rule, so it isn't mandatory. Time period set forth, blah, blah, blah. But you can't get it to arbitration, according to this, unless it's mandatory, apparently, no earlier than 91 days after the filing of an answer. And most people don't file an answer. On a written stipulation by the parties, on a motion by the party, on the judge's own initiative. Right? If you don't appear and file an answer and tell them where you're at and where to send the paperwork, they're not going to send you. You're not going to get the notices and the motions and all this other stuff. And when you go look at the record online, you're not going to see this private stuff happen in an arbitration because that's what happens in arbitration. It's private. Yeah, this thing's pretty good. Let me pop through this real quick. McHenry County further requires small claim actions are subject to arbitration when a jury demand is filed. Case may also be transferred to the arbitration calendar from other court calls or divisions. These arbitration eligible cases are litigated before a panel of 3 attorney arbitrators in a hearing resembling a traditional bench trial. Bench trial. Who's heard of a bench trial? May I go through arbitration before I go to... Must I go through arbitration before I can go to trial? Yes. There you go. If it's mandatory, you got to go to arbitration first. Can I make the arbitration hearing? May my spouse represent me? Unless your spouse is licensed to practice law, he or she may not represent you in your arbitration hearing. You must either represent yourself or have an attorney represent you. If I'm an officer of a corporation, can I represent the corporation? No. Corporations may appear as a claimant, assignee, suborgee, or counterclaimant in small claims proceedings unless represented by counsel. Right? So now you're not represented by an attorney, you're represented by counsel who's giving you legal advice. Here, this person was going to represent you, but they had to be. It looks like they got to be licensed to do it. So it's not just anybody's power of attorney. You must either represent yourself or have an attorney represent you. It would seem to me when they say, so I'm going to give you power of attorney and make you an attorney. You should be able to do that. But I don't know what they're going to say. What does this say? How do I have to pay the arbitrators? No, the state of Illinois pays arbitrators from mandatory arbitration fund. Go figure. See, a lot of these cases don't start as arbitration cases. They go in as some kind of civil action, and then it gets evaluated and determined if it fits within the criteria to be arbitrated. So it doesn't have an arbitration number, right? It's going to have some kind of civil number. Where are the arbitration motions heard? The supervising judge of arbitration in courtroom 202, here's the arbitration motions. This is what I'm talking about. In this county, room 202 is supervising judge. In Rose County, I don't remember what room it is, but the supervising judge of arbitration is the probate judge. As it should be. He's the judge approved. He's the one who decides. It's not the probate court, it's the probate judge who determines who's going to be a guardian ad litem, who's going to be an administrator, and so forth. Maybe not the actual case as it's running, but he determines who's who in the zoo. If a case is filed as a law division case, but it's really an arbitration matter, how do I put it on the arbitration hearing schedule? Transferred to the arbitration calendar by making an appropriate motion before the law division judge whom the case was assigned. Now, it doesn't say it needs to be a motion with both parties. It could have been an ex parte motion. Hey, would you move this over to the arbitration calendar? It went into the law court. You as the defendant file it into law court. They move it over to arbitration, and you keep going to law court. And when you get there, they act like they don't hear you. A case pending in arbitration may be transferred to the law division by filing. Okay, you can do it the other way too. Ba-doop, ba-dip, ba-dip, ba-dip. Can arbitrators hear motion? The arbitrator's authority to hear motions is limited. The authority and power exist only in relation to the conduct of the hearing at the time it is held. Thus, the arbitrators can hear and determine motions to exclude witnesses, motions to some other kinds, but so forth. Any other motion pertaining to the case must be brought at the appropriate time and in the appropriate manner before the supervising judge of arbitration. Probate judge in Kane County. But first you got to get it on, on the motion calendar. I'm not sure how you do that kind of stuff. That's, why I'm bringing this up. Well, we got to go ask these questions. Well, how do I get it on the motion calendar? Where's the procedure to get it on the motion calendar? I don't need legal advice. I know what I want to do. I want to put it on the motion calendar. Special rules, yes, Rule 222. I'm not going to get into that one right now, but that has some good stuff. May I call the maker of a document? Yep, we read that before. You can subpoena the maker of a document. When you find the damn documents, you can subpoena the maker. Prior to the arbitration hearing, who issues the arbitration summons? Before an arbitration hearing can proceed, all parties must have been served a summons. The Office of the Circuit Court of McHenry issues the arbitration summons as well as necessary aliases. But that's if it's an arbitration case. What if it's transferred, right? These are the things. Well, what if it's transferred from law? Does that mean there's still this summons? Because if there's been a summons, you're not getting the mail. When will the arbitration hearing date be assigned? There is another date on the summons. Do I need to attend that date as well? Yes, the summons contains a return of service date in the first paragraph, which sets before the supervising judge of arbitration. Right? So you're going to go to that supervising judge first. All parties must appear in court on the return date, unless otherwise excused by order of the court. You got to appear before the probate judge for that first hearing. On whatever the return day is on the summons, you should be going to the supervising judge of arbitration. If the defendant fails to file an appearance on or before the return day, an order of default may be entered, at which time the arbitration hearing date will be removed. Right? If you don't appear at the first hearing on the return day, an order of default, boom, they just go to order of default right there. Boom. There was never anything else scheduled afterwards. They've got a default judgment against you. Now, it doesn't mean that they've gotten an award yet, but there's a default judgment, and it could be the default judgment's in, it's going to be whatever amount the judge decided it to be. What if I'm a defendant and wish to contest the allegations in the complaint? If any defendant wants to contest the claims made by the plaintiff, the defendant must file an appearance and an answer. No case will proceed to arbitration unless an answer is on file to any complaint, counterclaim, third-party claim, affirmative defense. For the appearance, there is a form available in the office of the circuit clerk, and the clerk will advise you on the appropriate fee. So you need to tell them you need to appear in an arbitration hearing. For the answer, there is no form available. The defendant must answer each allegation of the complaint in writing. For example, if there are 6 paragraphs in the complaint, the answer must contain either an admission or denial of each paragraph contained in the complaint. So you get to go through and say, I deny this one for this reason, and yeah, I agree with this, right? Whatever. Because a lot of the things they write aren't, there's no claim upon which relief can be granted. It's just a bunch of shit written on paper. They're dependent on you not showing up. Where can I get the forms required for my case? Most required forms are available at the office of the circuit clerk. What if the parties settle the matter prior to the hearing? If the parties settle the matter prior to the hearing, the parties will be required to appear before the supervising judge of arbitration at the scheduled motion call before the arbitration hearing date to submit the appropriate stipulations and or orders to dispose of the case. What happens if one of the parties appears but does not present a case? Illinois Supreme Court rule provides that all parties to an arbitration must participate in good faith in a meaningful manner. If the panel unanimously finds the party has failed to participate in a hearing in good faith and in meaningful manner, they may so state on the appropriate 91 form or any award along with the final or factual basis thereof. So, I'm just wondering, because there's times people said, well, I went to court, and they act like I'm not there, right? Well, it's because you've never appeared, so you're not really making a good faith effort to be part of the thing. You're just an instigator. You didn't appear. Well, a panelist announced the award to the parties on the day of the hearing. The panel does not announce award. Litigants may wait for the award or call the arbitration center later to have the award read. You just call them and they'll read it to you. A copy of the award will be mailed to the litigants who have filed an appearance. Right? Who did it say to call? It said to call the arbitration center. So find the number at the arbitration center and call them and see if there's any awards for or against you in your name forward and backwards, right? Surname, comma, given name, first name, last name, maybe your address. Ask them, well, how do you have the cases indexed? And we'll find something that you can use to tie the two together. Right? It looks like it was in the circuit court of the 16th Judicial Circuit, Kane County, Illinois, and it has this case number on it. Can the parties enter a stipulation for the amount? Yes, the parties may stipulate to an amount different from the award after the hearing, but prior to entry of judgment on the award. So, okay, they're going to have the hearing and they're going to make an award, and you're going to say, well, I want it for more than that, and you're going to make a stipulation. They are, right? But it won't. The judgment won't have been given yet. What happens if neither party asks for a judgment on the award to be entered? So neither party asked for the judgment. This is after the award's been thought of, but the final judgment hasn't happened yet. At the time of arbitration hearing, the court sets a status date called the judgment of award date, approximately 35 days after the arbitration hearing. The parties receive a copy of the court order setting the judgment on award status date along with a copy of the award via the mail. Typically, one of the parties will move for judgment on the award and the status date. The judgment on the award status date is mandatory for all parties. If neither party attends the status date, the supervising judge of arbitration may dismiss the case for want of prosecution. So, you're the defendant. They want you to be. They're the prosecution. They've gone through this fiasco. They got an award, yet they haven't accepted it. Right? They haven't asked for a judgment on there. If you point it out to the judge, he's going to dismiss the case for lack of prosecution, because they didn't take it to trial. That if they don't like the award that's been offered by the arbitration, they're supposed to come within 35 days and say they don't like the award and stipulate a different number, or say they want to take it to trial. And if they haven't done it, so if this award is still sitting there, has never been judged, and it's more than 35 days after the frickin' hearing, and you bring it up to the supervising judge of probate, right? Not the arbitration judges, but the supervising judge of the arbitration judges. You can dismiss it for lack of prosecution. Things to know when appearing in court. What is service and why is it so important? A party is served when he or she receives a summons. Usually the sheriff delivers a summons to the defendant, and there is a fee for the service. Jerry, a brother here in Michigan, Jerry Stanton, people may know him. I know he sends lots of emails and stuff out. He just got served last week, not by the sheriff, but by some private server, and he got served a copy of the complaint, but not a copy of the summons. Well, it's the summons that needs to be frickin' delivered with a copy of the complaint, but it's the summons that tells you to come to court, and all they gave him was the copy of the complaint. So I said, well, Jerry, get a hold of the attorney and tell him you need his certificate of good standing from the clerk of the Supreme Court, and see what that does, see if he sends it to you or not, and then if he does, check that name against the name that's on the thing, even if he's using the right name, right? He didn't follow the rules. He did not serve you a copy of the summons, which is the part he's supposed to serve you. What is service? Service is the formal process of which a party to a case is informed that the case has been filed against him or her and that he must appear in court on a specific date. Well, the complaint doesn't do that. Proper service is important because without it, a court does not have the power to order a party to do anything to resolve the dispute. A party is served when he or she receives a summons. Usually the sheriff delivers a summons to the defendant and there is a fee for the service. So he didn't get a summons. And if you get a summons, you're going to go by the return date and go to the supervising judge of arbitration. Or have gone to arbitration ahead of that to see if you can take care of it or, whatever the deal is. But my point is, if you're getting served papers by anybody, you look to see who the attorney is and you just fire back to him and say, is this the name that is on your certificate from the roll of attorneys? Or you call and ask the keeper of the roll of the attorneys whatever they want you to do to get from them if this is the same name, and if it isn't the same name, that's the complaint you're going to put in to the group that is over the practice of law, which is the Supreme Court. Supreme Court, in the states I've looked at, has exclusive jurisdiction over the practice of law, and they set up the rules. And if you don't follow those rules, you're not going to practice law in the state. And if you don't follow those rules and you're practicing law in the state, then it's either false personation or official misconduct. A summons is a pre-printed legal form that tells a defendant that he or she is being sued and contains the date the defendant must come to court, the return date. An appearance is a written form of what's an appearance? An appearance is a written form the defense must file with the clerk of the court. Okay, what clerk of what court? Now here we go. The clerk of the court of the arbitration, I think, is the Supreme Court clerk. We're going to have to find that out, but you got to file an answer with somebody. Or is it just the arbitration administrator? What is an answer? An answer is a written statement a defendant must file with the court. It addresses each of the paragraphs in the plaintiff's complaint by admitting or denying the allegations the plaintiff is making. What's a motion? How do I file one? Filing a motion with the court is the manner in which a party officially requests the court to do something, such as rule on an issue or schedule a hearing. A party filing a motion must send it to all parties in the case and also file it with office of the circuit clerk. What is a notice of motion? A notice of motion is simply the form the party files with the court, telling the court that all of the parties to the case have been informed that the motion has been filed. Okay, that's just standard court stuff. Just real quick, what the form should be looking like, right, is in the circuit court of the 22nd Judicial Circuit, right? Now again, when we looked earlier, it said that the Supreme Court, or whoever, that the circuit court 4 had decided that the circuit courts in the judicial circuit would be the courts that heard arbitration hearings, and the circuit court of the 22nd would be in the 22nd. Well, we never see this one, right? The circuit court of. So if you're in Illinois and you're seeing paperwork that says the circuit court of, this has to do with arbitration. Circuit Court 4 would be the law court. Circuit Court of is the arbitration court. Of. And it continues on until finally there's, right, here's one for of. This is a notice of motion. Rejection of an award. Sorry, here's the one for the motion. Gen number. There's that gen number. That was on Roe's original complaint. Gen number 13-17026 or 206026, I think. Right? They use gen numbers. The of court uses gen numbers. Right now they're going to call it a case number. They're going to do something else on the other paperwork, but this is, again, they're showing you what it should look like. Right? And so if you're not seeing this, we could say it's a simulated legal process. Yep. Notice, motion, affidavit of certificate of attorney, affidavit of service. Good stuff. Okay, well, this video is getting way too long, and I'm sure it's been humming like crazy, so I don't even know if you guys listened to it. But I said what I wanted to say, and I'm sure I'll have more later. We'll talk again.